This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. We appreciate you agreeing to participate with us today via Zoom. We believe it's probably the best way to go ahead and conduct oral arguments in these unusual times that we find ourselves in. Having said that, even though we are doing this oral argument by Zoom today, we will follow the same procedures and protocols just as if we were all standing in the courtroom together today. Before I get started, I want to be sure and introduce our panel for this afternoon. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. I do not expect that we will encounter any technological problems today, but if we do, everybody remain calm. We'll get those worked out, and I will make sure and I will assure each of you that any technological problems will not prejudice your clients in any way. So, Ms. Tebner, anything we need to take up before we call the case?
No, Your Honor.
All right, call the case then.
Linda Michelle Watts versus David Wayne Suter.
All right, we will hear from the appellant.
Good afternoon, Judge Stafford. Thank you very much. Judge Armstrong, Judge McGee, it's a pleasure seeing you over Zoom. Appellant's reserving 2 minutes for rebuttal.
All right, thank you, sir.
Thank you. And if it pleases the court, Your Honor, my name is Jason Ridenour. I represent the appellant, David Suter. This case, while if one were to look at all the facts that were talked about, the trial court could look a little daunting. It's a very simple case once you get down to it, especially here on appeal, because we're dealing with a very limited issue of error. At trial, there was the question both parties raised in their pleadings of the disposition of proceeds of the property located at 7196 Great Oaks Road in Germantown. What had happened, the parties were involved in a lengthy relationship. They were not married. There was a question of marriage at the trial court level, but it was stipulated to be annulled, which was approved by the court. So the parties were not married, but in 2013, they obtained property as joint tenants with right of survivors. Now, at the time of the purchase of this property, Mr. Suter was the only person to put any money towards the property. He put a $49,000 approximate down payment on this property in 2013. The property was obtained by a third party, and Ms. Watt's name was placed upon the deed as a joint tenant with right of survivorship. Mr. Suter's position, as he's stated throughout these proceedings, has been that the only reason her name was put on the deed was because of the relationship. He wanted to help with her credit. Ms. Watts did not contribute any money towards the purchase of the property. And the issue of dispute is whether or not she's contributed any money at all towards the property, frankly. And so when we get down to it, that's essentially the gravamen of the entire appeal and of the issues is, what do we do with this piece of property and its proceeds? Now, there's essentially three issues that Mr. Suter raises on appeal that we would like to talk about this afternoon. The first is whether or not there was an actual agreement or a legal interest that was created with Ms. Watts by her name being placed upon this deed in 2013. That's the first issue. The second issue is, assuming that she does have a legal enforceable interest in this property, the question then becomes is what is the contributions of these parties with respect to dividing the proceeds of this asset? Because it's our position, it's clear in Tennessee law that when you have joint tenants and you divide the proceeds of that asset, that you must consider the contributions of the parties towards that property in determining who gets what in terms of the proceeds of that property. And then the third issue is the issue of attorney's fees. We were granted $5,000 of attorney's fees trial because of unsupported claims, frivolous claims that were filed by Ms. Watts as determined by the court. And we are asking for additional attorney fees at trial as well as attorney fees on appeal. But so getting to the first issue, the issue of this agreement, or the issue rather of the agreements between the parties, and also the second issue, which is the issue of contributions. The issue of trial court error is clear. The trial court after going through all the facts related to this case, and just for background, I know your honors have reviewed the record, but just as a reminder, the appellee had asserted numerous unsupported claims of fraud and unjust enrichment, which the court found there to be no basis for. And in fact, appellee's own counsel in closing argument admitted that there was no basis for many of these claims. And we contend there was no basis for any of the claims. However, and the trial court agreed with us.
Question, Mr. Ridenour.
Yes, sir.
Trial court find that there was no basis to this, or did the trial court just essentially say, I'm not going to decide this?
There was no basis. And actually, in the court's ruling, the court specifically noted the fact that counsel for the appellee admitted there was no basis. Just as an example, she was asking for my client to pay her for money that a health insurance company had paid for a surgery. My client was out no money. She wasn't damaged in any way. She essentially was just asking for $400,000 of medical benefits that had accrued over a decade. It was.
I understand that, but number 8 of the court's finding on page 2 says the court cannot speculate what agreements were made because all the deals were informal in nature and both parties have credibility problems.
And Your Honor, I'm sorry to interrupt.
What does that all mean?
Well, Your Honor, that was the court's way of punting with respect to determining Miss Watts' interest in the actual property. It was Mr. Suter's allegation at trial, which we put on proof, that when the parties were placed on this deed, there was never an agreement that Miss Watts would ever be have an actual interest in the property. She was simply on the deed to help her credit. And so that was the argument at trial. And I believe, Your Honor, that was the reference that that Judge Weiss was making when he made that determination. He said, I'm not going to make any findings as to the parties' agreements, which we contend are error. The trial court has to, we would contend, at least make some finding of fact and law with respect to that. And then if Your Honor looks at that next paragraph, paragraph 9, it says further, just as if the parties were married, the court would not have any ability to parse through the course of a marriage to determine who paid what or who did what when. Such transactions are all part of the relationship, and the court cannot unravel the relationship. So this was all part of Judge Weiss indicating that he wasn't going to make any findings about any of these things. He didn't make any findings about contributions of the parties. Both parties put on evidence about what they contend they paid towards the property. Judge Weiss said, I'm not going to make any of the findings. All I'm going to do is just assume both parties as joint tenants each get 50% of the property, of the proceeds. I mean, and we contend that that's error because the Harris case, the Parker v. Lambert case, they talk about whenever a court is looking at these issues of joint tenancy, the trial court has to make findings as to the contributions, and Judge Weiss didn't do that. But as to Your Honor's original point regarding the finding of claims, I mean, the court made it very clear that Mr. Snyder, who is a counsel for the appellee, acknowledged that the debt that Ms. Watts wouldn't be entitled to that debt relief because it wasn't anything that she actually expended. So it was admitted by the court that the claims that were asserted weren't claims for which she was actually entitled for relief. And that was the reason why Judge Weiss granted attorney's fees of $5,000 for having to defend those claims. And Your Honor, that
just a second. I understand that there are some specific claims that appellee admitted that they weren't entitled to credit for. My follow-up question to this is the trial court said essentially both parties have credibility problems. And then somewhere over later on in the order, he said that both parties have unclean hands. Are those two findings sufficient to allow the court to not make findings of fact in this type case?
No, Your Honor, but and I will state that in looking at those findings, it's important to understand the context of those findings. The unclean hands reference by the court was talking about another claim that was made by Miss Watts, and that was, and we could get into it and spend a lot of time talking about it, but there was a factual situation where where Miss Watts signed a marriage license and Mr. Suter signed it as well, and that they were going to be married for purposes of Mr. Suter continuing to stay on her health insurance because Miss Watts' employer was cutting off the support of committed domestic partners, which is what Mr. Suter was, and he had health insurance benefits through Miss Watts' employment. And they were cutting that off probably because of Obergefell and the issue of homosexual marriages being legal. So therefore, what ended up happening was they made the decision that they were going to get married for purposes of him continuing on as a spouse for the health insurance. Well, whatever happened there, the issue was they signed the marriage license to get married. There was a dispute afterwards. The issue of the marriage license was before the court. We stipulated that the issue was that there was no marriage. We've always admitted all of the facts related to this. There was never any dispute as to the facts. The only question is whether or not there was a legal marriage as a result of the signing of this marriage license and delivery to an officiant with no ceremony, which we just, according to the statutes, we just stipulated that this was not an appropriate marriage and it was a null. And so when she was trying to miss part of the fraud claim that she was trying to make in order to get this $400,000 of money that she wasn't entitled to, Ms. Watts was making this sort of broad, ambiguous claim that this was all reference of like this fraudulent scheme that she was also involved in, but nevertheless, and so that was kind of what Judge Weiss was referring to when he talked about unclean hands. She can't really make this allegation of fraud against him because they both signed this marriage license. There was a text message exchange where she admitted that this was this idea that they were going to get married and he was going to get health insurance. So that was what the unclean hands comment was about. It had nothing to do with the actual property. And so the issue of that was that. So that's unrelated. And the issue of credibility, when the court talked about that, the court was talking about credibility with respect to talking about the personal relationship of the parties, and the court sort of couched it as, I'm going to treat this like a marriage, and just like any marriage, I'm not going to listen to who said what, who shot who shot John. I'm just going to assume that all this property is jointly owned, which is not legally speaking is appropriate under the law.
How do we know that's what the court was alluding to? Because it doesn't tie that credibility finding to any specific thing that I could tell.
Well, Your Honor, I was referring, if you look at volume 3 of the transcript, volume 3 of the court transcript, I think it might be volume 6 of the record. It is it's the ruling that was incorporated into the order. So
I've looked at the transcript, and all it does essentially, or the court's ruling, if that's what you're referring to, and it basically parrots back what the court said in its order. I couldn't find a specific reference to what the court was discussing as far as credibility.
Can I read the relevant portion, Your Honor?
Please, go right ahead.
If Your Honor looks at page 284 of the transcript, it's the first full paragraph on that page. It says, unfortunately, this court cannot and will not speculate what agreements the parties made in the past because from an outsider's position, both parties have credibility problems because, again, the handshake deals or the pillow decisions made in the intimate relationship between the parties, there is not a lot that the court can do. So the only reference to credibility issues was in context of this trying to figure out these people who'd been together for over a decade, trying to parse out what was these parties' actual agreements. I mean, obviously they were living together and they were doing things that weren't at an arm's length transaction. And the court felt sort of overwhelmed by that fact pattern and just decided to essentially say, I'm not going to make a decision, which we contend is error.
Okay. All right. Thank you. You still got your rebuttal time.
Thank you.
And we will hear from the appellate.
Well, good afternoon. That's my first time by Zoom, so I miss coming up to Jackson and all that. But let me start out by saying every once in a while.
Introduce yourself first.
I'm sorry, Kevin Snyder, and I have my associate here, Sean O'Brien.
All right,
For the appellee, Ms. Watts.
all right.
As I was saying, every once in a while you get, for lack of a good legal term, a bizarre case that quite frankly should not be up on appeal. And I believe this is that type of case. To kind of jut into it quickly, I think the court made it crystal clear that both parties have credibility problems. Both parties had unclean hands, and that includes our client. And the court took the evidence, did the best he could with the evidence, and made a decision that should be clearly affirmed. When you get past all of the issues involved in this matter, there's credibility problems all over the place, both from the claims that were made, the defenses that were raised, and this applies to both sides. It does. So I don't think opposing counsel's argument that you can limit credibility and unclean hands to one part of this and not apply it to all of it defies the record that's before your honors. What you've got is a highly unusual cluster of events that both sides engaged in. And in particular, the appellant seems to gloss over the fact that the appellant, for a good portion of this litigation, maintained the sworn position that they were legally married when he clearly knew they weren't, because there was never a ceremony. The stipulation came long into the litigation, after each side spent ridiculous amounts of money arguing about it. So that stipulation was ultimately done, but I think that factors into the credibility problems too. But what we're here about is the property division. And as set out in our brief, if the property is jointly owned, which in this case it was, our client was on the deed and
Say jointly owned, are we talking about as tenants by the entirety, tenants in common, or what?
tenants in common. I mean, when you look at it, and I don't think any of that is in dispute, opposing counsel, I think just said that, and I would absolutely agree with that.
Well, I asked that because Mr. Ridenour was using tenants by the entirety when he was discussing this, or perhaps I misunderstood him. But anyway, go right ahead.
Okay.
Let me ask you, Mr. Snyder, that tenancy, did it also include a right of survivorship in the co-tenant?
Yes.
Okay. So if Mr. Suter had passed, then Ms. Watts would own a fee simple in that property. Is that right?
All right, then I retract that a little bit. I'm not entirely sure off the top of my head. But I would presume that would be the case based upon the deed and the fact that they were both jointly obligated on the mortgage as well. I mean, essentially both parties were obligated on everything. Payments were made from a joint account. Ms. Watts made payments, additional payments directly to Mr. Suter as reflected in the record. And those were just the payments that she could document. And I think it's worth noting when you look at the record here as a whole, she documented payments made to Mr. Suter specifically to go towards this mortgage. But when you also look at the record and and again, this harks back to the credibility problems, Mr. Suter did not introduce a single payment showing he paid anything on the mortgage. And in fact, when you go back and look at the application for the mortgage, our client made more. And from a practical common sense standpoint, it defies common sense that Mr. Suter could have even obtained a mortgage on this property based upon his own income, which basically was disability or Social Security income. So when you factor all this in and you apply the presumption, as it should be when it's jointly owned, jointly titled, that type of thing, I don't think there's anything to overcome the presumption that was created. And it seems to me that opposing counsel in their brief is kind of ignoring that fact of basically saying, well, because he testified that he made all the payments, that somehow that overcomes the presumption. And it gets back to, as Judge Stafford read, Judge Weiss, the trial court, made specific findings of fact that both parties had credibility problems, both parties had unclean hands, on and on. If you look at the record in this matter, it is replete with contradictions, with unclean hands, with bad faith, candidly to the court on both sides. But we still have
Schneider,
yes.
Mr. Schneider, I have one question there for clarification. Does your client allege any ownership interest in this property as the result of any type of a gift?
No. Her position has been and has always been she contributed to it all along. She contributed in payments. She contributed by the use of her credit. She contributed, and it talked about in there, the sweat equity in terms of things she did to work on and improve and help care for this property, as well as the property before that.
Mr. Schneider, let me ask you a follow-up question then, because I've read your briefs, but I haven't obviously been through all of the record yet. And we have the issue here that the court has said that basically there were credibility problems with both parties.
Yeah.
So what evidence was presented to the court other than the testimony of the parties? What evidence was presented to the court to support what you're alleging?
Well, in terms of the evidence, in terms of the actual, if I'm understanding your question right, that the property is jointly owned by Ms. Watson.
You're saying that Ms. Watts had made contributions. She's alleging an ownership interest not as a result of the gift, but because that she had made contributions to this property.
Yes.
And what I'm asking you is, the court has basically said that neither party is credible in their spoken word, in their testimony. So you're saying that she's presented proof of these contributions. And I'm asking you, was there any other proof, any other documentary or evidentiary proof presented to the court other than your client testifying and saying, I did these things?
Yes. Certainly, as Ms. Watts testified, she contributed. Mr. Souter said she didn't. However, our side was the only side that actually introduced documents and evidence to back up our client's testimony. In particular, you've got the deed of trust. You've got the financing agreement for the home. You've got a copy of the deposit, the original earnest money to close on the property, which was from a joint account. We introduced bank statements of payments that she's made. We introduced pictures in terms of sweat equity of different things she did both in that house and or the previous house. Multiple items of documentary evidence, which I think is separate and distinct from taking one party's word over the other. Now, conversely with that, Mr. Souter did not introduce a single payment showing he made any payments towards the mortgage on this house. And I think that's critically important to answer your question when you look at this of, all right, of basically you're the trial court. I can't take either party at their word. So who actually has something to substantiate which they're claiming? Because I, quite frankly, as the trial court, don't believe either side. And we were the only side that actually introduced documentary evidence to back up what our client is saying. If in fact Mr. Souter was claiming this, where are all of his canceled checks? Where are all of his payments? How can he explain on the loan application that he didn't have sufficient income to buy this house without Ms. Watts, because she actually made more than him? She was actually working, you know, and it kind of goes on and on. And I think the analysis by the trial court was proper, given what the trial court candidly was dealt with by the behavior and actions of both sides. Of the trial court had to make a decision based upon an impossible set of circumstances where both sides were acting in bad faith and both sides lacked credibility. So when you take a step back and look at it as a whole, if you're not believing either side, you're looking for a third party or documentary evidence to back up to see who is more believable. And when you look at that, and in particular, and you look at applying the presumption, There is nothing in the record to overcome that presumption of joint ownership. And therefore, the trial court correctly found that the property should be equally divided, or the equity in the property equally divided, if that makes sense. Now, yeah.
Mr. Smith, you are aware that in Harris versus Taylor, the property was jointly owned with right of survivorship, yet the trial court went through this analysis about making a determination about the excess contributions. Isn't that right?
I believe they did, yes.
How was this case different from Harris versus Taylor, in your opinion?
Well, I think to be candid with the court, I think this case is drastically different than any case I've ever seen, just because of the sequence of events that got the parties in the position that they were in. Basically, had this been a normal situation where you didn't have basically the appellant saying, well, I'll give you a divorce, or I'll stipulate to an annulment if in fact you give me the house and the equity, you know, and I think there's just factor after factor like that that distinguishes it from that. Outside of that, you've got issues of, like I said earlier, of the payments that were made in. I think this is just such an unusual set of circumstances.
Right. Was there any stipulation at trial about who made the down payment of $49,000?
I don't believe there was a stipulation of that, no.
Was that contested that Mr. Suter made the down payment of $49,000?
To be honest, I don't recall. But my understanding is that both parties, because keep in mind, Mr. Suter originally testified that the house before this house was jointly owned by him and Ms. Watts. He testified to that one day, and then when we came back to trial, he corrected himself. And that gets back to the overall credibility problems of both sides of, all right, well, the house that was sold to get into this house, which Ms. Watts contends she improved and helped with and did things for, Mr. Suter originally testified that was jointly owned with Ms. Watts. He testified to that one day, then he comes back and says it's not. Well, that I actually owned it, and therefore I contributed everything towards it. So, I mean, again, it gets back to the who do you believe and what do the documents actually back up and show? Because if you're going to look at the presumption first, that it is jointly owned and in theory should be jointly divided, what documentary evidence, if any, does the appellant have to back up or add credibility to his uncredible testimony?
You mentioned, let me ask you this question. You keep mentioning this presumption. What presumption are you talking about?
The presumption of joint ownership, and we set that out in terms of.
Is this because of the marriage situation?
No. And in particular, I'm going back to the Harris case that Judge Armstrong was talking about, where it talks about a joint tenancy is a tenancy with two or more co-owners who take identical interests simultaneously by the same instrument and with the same right of possession, which is exactly what we have here. So therefore,
so actually this marriage or annulment has nothing to do with anything. Is that correct? From the analysis that we're going to look at.
I don't think it does, in the sense that that issue was resolved and it doesn't appear to be an issue of the appellant on appeal, other than, and I would caveat this, other than the credibility, the unclean hands, and all the other issues that the trial court found with both parties.
What then why isn't this case, shouldn't this case be analyzed just as any other case, like a dissolution of a partnership?
Well, I think that's essentially what the court did. To be candid, I think the court looked at trial court said, I'm not going to get into all this because basically this is a cluster. So the trial court looked at what was in the record, what was in the evidence, and made a partition, if you will, of how to divide it up.
Let me ask you, Mr. Snyder, you indicated in your argument that perhaps the down payment for the property that we're dealing with now was made from the sale of this other property that was jointly owned by the parties. When these two properties were purchased, were the parties holding themselves out as being a married couple? Was this after they obtained the marriage license?
I'm out of time, but I'll be happy to answer your question. Can I answer your question?
Sure, go ahead.
No, the marriage issue came about later, and obviously it's been Ms. Watt's position that certainly she signed the marriage certificate, but they never actually had a ceremony, and this occurred after the dispute started, which was after the purchase of the house in dispute. So when you look at this as a whole, my client's position is she felt like she was being extorted because she never agreed to complete an actual marriage, and unless she agreed to sign over her equity interest or joint ownership equity interest in the house to Mr. Suter, he wouldn't give her a divorce. And he followed up on that threat by keeping it that way well into the litigation of this case. Because if you look at the original part of this case, this was to get an annulment based upon a fraudulent marriage that Mr. Suter maintained was an actual marriage until he was actually called out upon it at his deposition and proven that he was lying, that no ceremony actually occurred when he said it did. And that's the only time he stipulated to it.
So to make sure I understand your answer to my question, in regard to that other parcel of property, which you say was the deed was taken as joint tenants, they had not applied for this marriage license, but in connection with the property that we're addressing now and this appeal, that was acquired after they obtained the marriage license. Is that right?
No, to be clear, and if I'm understanding your question, the Great Oaks property was already purchased and already in place before this other sequence of events started.
Okay.
Does that answer your question?
I think so.
All right, we will hear from the appellant in rebuttal.
Thank you, Judge Stafford. We need to be clear. No one during the trial ever disputed that Mr. Suter was making all of the payments associated with this property. In fact, the questioning at trial by Mr. Snyder was that he was making it. You asked him if he was making this mortgage payment of $1,218 a month. He said yes. Ms. Watts never come on in the stand and said, you know what, this mortgage isn't being paid. So none of this was ever in dispute about any of the payments made. It's just now on appeal, we're talking about, well, we didn't produce canceled checks. Well, we didn't produce canceled checks because it wasn't an issue in dispute. Mr. Suter said it was paid and nobody disputed it. And so that's I think that's important to note. It's also important to note that a lot of the things, the factual issues that Mr. Snyder stated, it's just not supported by the record. I addressed a few of these things in my brief. Even some of the statements made today, I talked about specifically in my reply brief, and I pointed in the record where it's just not accurate what is being stated. And I'm not going to waste time going through each of those because I think Your Honors has the record, and I'm sure it'll be clear. I want to make clear, because the credibility and the unclean hands issue seems to be, I think Your Honors have asked about that a few times. We already talked about the unclean hands passage on page 284 of the transcript. The credibility issue being limited. On 285 of the transcript, it's the unclean hands issue is limited. It again is only talking about the tort claims alleged by Ms. Watts, specifically the issue of this marriage. So I think we need, hopefully Your Honors will see that the issue of credibility and unclean hands, that was very limited to Ms. Watts' claims. It wasn't with respect to Mr. Suter's testimony generally. And if Your Honor has any questions, I'll be more than happy to address anything. I know.
Let me ask you, the $1,000 a month that Ms. Watts claimed that she paid to Mr. Suter each month, is that disputed? And if not, what was that payment for? Yes, it was disputed. In Your Honor, Exhibit 8 was presented by Ms. Watts. She had said,
in the testimony, in her testimony, that she had stayed at the residence from June 2013 when it was purchased until I think approximately February of 2015 was her testimony. And she produced bank statements for that period of time. And she said that while she was there, she was making payments. Now, the issue in dispute, and really, in my opinion, the only like factual issue that's actually in dispute, if you look at the record, is how much she was paying during that time and what were those payments for. And so she testified that she was paying $1,000 a month for approximately 21 months, and that it was all reflected in these bank statements. But you look at the bank statements, there's only about $7,500 that's actually reflected in these bank statements. And it's payments transfers to Mr. Suter. And it was disputed at trial what these payments were for. And so the payments for Mr. Suter indicated that these payments were essentially for her staying in the residence while she was there. And that's supported by the fact that she stopped making these payments when she left the residence in February of 2015. She says it was just part of her payment towards the mortgage and so on and so forth, which again is not supported by the fact that she stopped making these payments when she left. And by the way, she left voluntarily in February of 2015.
All right. Thank you. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Ms. Tivner, anything we need to take up before we recess to the call of the next case?
I know, Your Honor.
You may recess court then.